Your phone lights up at 6 a.m. with a notification you don't expect. Motion detected at the front door. You open the app half asleep, and there are 2 police officers standing on your porch. Before you can even process what's happening, one of them reaches up and the picture goes dark. A voice says something like, "Just standard procedure," or "for our safety," and then nothing. No more video, no more audio. Just a black rectangle where your front door used to be. It sounds like a small, forgettable detail, a hand blocking a lens for a second. It isn't. That single motion is one of the more calculated moves in modern policing, and how you respond to it in the next 10 seconds can shape everything that follows. By the time this video ends, you'll understand exactly why officers do this, what the Supreme Court has actually said about your porch and your camera, and the precise sentence you can use to shut the whole thing down without ever opening your door. Stick around, because there's a second piece to this that almost nobody talks about, a setting buried in your camera app that determines whether any of this even gets remembered. Quick note before we dive in. There are really only 2 ways a doorstep encounter with police goes badly. Either you talk yourself into trouble, or you get physical and it escalates into something far worse. I put everything I know about avoiding both outcomes into a book called Say This. Links in the description if you want it. Now, let's break this down. Think for a second about what's actually going through an officer's head as he walks up your driveway. He knows the camera above your door is running. It's capturing his face, his tone, every word out of his mouth, the exact way he phrases his questions. And unlike a human witness, that lens has no bias, no fear, no memory that fades or gets reshaped after the fact. It just records what happened. That makes it, in a very real sense, the most inconvenient witness in the entire interaction. The one he can't reason with, intimidate, or charm into seeing things his way. So before a single word gets exchanged, there's a strong incentive to kill that witness first. Cover the lens, and suddenly it's just his account against yours. And only one of those accounts comes with a badge and a report-writing template behind it. That's the entire strategy behind the gesture, and it explains why it keeps happening, even though no training manual anywhere actually instructs officers to physically block a homeowner's security camera. If you think this is theoretical, it isn't. In March of 2024, a large team of federal agents arrived at a house in Little Rock, Arkansas before sunrise, roughly 10 vehicles worth of personnel, to execute a search warrant. The homeowner, Brian Malinowski, ran the city's airport. As agents in tactical gear approached the front entrance, the officer at the front of the line placed a strip of tape directly over the doorbell camera lens. No knock. No phone call, despite his number being written right there in their own planning documents. The camera went dark, the raid began, and within roughly a minute, Malinowski was dead, by most accounts believing his home was under attack by intruders. None of the agents on scene had their body cameras rolling, even though department policy required it. So picture that. The one camera on the porch, blacked out. The body cameras, off. And a man's death, with essentially no independent footage of how it unfolded. That is precisely the outcome this tactic is designed to produce. Erase the neutral record right before the moment nobody in a badge wants documented. Here's the thing, though. Most people, faced with a hand rising toward their camera, fall into one of 3 traps, and every single one of them plays directly into what the officer wants. The first trap is the instinct to physically intervene. It's your house, your property, your camera. So the reflex is to throw open the door, or worse, step out onto the porch to confront him directly. Totally understandable reaction. But think about what that actually does. You've just abandoned the one place where the law is overwhelmingly on your side, and walked into a tense, adrenaline-charged standoff on his terms instead of yours. Here's what a lot of people don't realize. Back in 2013, the Supreme Court ruled in a case called Florida vs. Jardines that the area immediately surrounding your home, your porch included, is legally treated as an extension of the home itself under the Fourth Amendment. So the second you cross that threshold to argue, you're voluntarily giving up the strongest legal ground you'll ever stand on. Staying inside isn't passivity, it's strategy. The second trap is politeness. You crack the door open just to hear him out, just to be reasonable and get it sorted. This is the one that does the most damage precisely because it feels so harmless. The instant that door swings open, the entire legal landscape shifts. Now he can see into your home, he can smell what's inside. Anything visible becomes fair game. And every sentence you say from that point forward is something you volunteered freely and without being compelled, which means it can be used. You might worry that refusing to open the door makes you look like you're hiding something. You're not obligated to answer a knock at all. Full stop. That's not a loophole. It's a right the courts have upheld for decades. Declining to open your door proves nothing except that you know your rights. Looking cautious isn't a crime. Opening that door, on the other hand, is often the exact moment a casual knock turns into something much closer to a search. The third trap is quiet compliance, just assuming the officer must be within his rights, because he said officer safety, and he's the one wearing the uniform. This is arguably the most dangerous trap of all, because in the vast majority of these situations, that phrase is doing a lot more work than it's entitled to. Officer safety is a legitimate legal concept, but it only applies when police already have lawful grounds to be acting, an active warrant, or genuine unfolding emergency. It's not a blanket phrase that suspends your property rights on your own porch. Back in 1984, the Supreme Court defined a seizure of property broadly as any meaningful interference with someone's right to possess and control that property. Reaching up and taping over your camera, spinning it away, or ripping it off the wall fits that definition. Without a warrant or a genuine emergency in progress, that's not routine procedure. That's interference with something that belongs to you. So let's ground all of this in actual case law, because I don't want you just taking my word for it. I want you walking up to that door already knowing exactly where you stand. Start with Jardines again, since it really is the backbone of this entire situation. The court described what's called an implied license, essentially the same limited permission granted to a mail carrier or a kid selling raffle tickets door to door. An officer can walk the normal path to your door, knock, wait a reasonable amount of time for an answer, and if nobody responds, leave. That's the full extent of what that implied license covers. Nowhere in that scope is permission to disable your security equipment. No delivery driver, no census worker, no trick-or-treater reaches up and blacks out your camera on the way to your doorstep. The moment an officer does something no ordinary visitor would ever do, he has already stepped outside the only legal justification he had for being there in the first place. Then there's your right to actually film the interaction, which is a bigger deal than most people realize. Multiple federal appeals, courts have affirmed that citizens have a First Amendment right to record police officers carrying out their official duties in public. One of the earliest and most influential rulings came out of Boston in 2011, a case called Glick ver. Cunniff, where a man filmed officers making an arrest in a public park and was himself arrested for it. The appellate court sided firmly with the man who was recording, not the department, and made clear that documenting police conduct in the course of their public duties is constitutionally protected activity. Numerous circuits have echoed that reasoning in the years since. Now, line up what that means for the officer standing on your porch. He's on ground the law treats as part of your home. Disabling a camera, you have every legal right to operate. In order to hide conduct, you have every legal right to document. That's not a position of strength. It only feels intimidating because most people don't know these facts in the moment and freeze up instead of acting on them. Now for that second layer I promised, the one hiding behind the first trap. This one's about audio, not video. A lot of people assume that even if the picture is fine to keep, recording an officer's voice must be illegal because they've half remembered something about two-party consent. States requiring everyone's permission before you can record a conversation. Some officers know this misconception is common, and a few will lean into it, telling you to mute the audio or claiming you're breaking wiretap laws by recording them. Here's what almost nobody carries into that moment. A 2012 federal appeals court ruling, the ACLU versus Alvarez case, addressed this directly and found that an officer performing public duties out in the open has no reasonable expectation of privacy in what he says while doing his job. Those consent and eavesdropping laws exist to protect genuinely private conversations, a phone call with your physician, a hushed exchange in your own kitchen. A group of officers announcing themselves and speaking on a stranger's front porch doesn't fall into that category. So in most jurisdictions, your doorbell camera capturing what an officer says at your door is exactly the type of recording protected by the First Amendment. State laws vary somewhat, so it's worth knowing your local rules specifically, but the underlying principle holds nationwide. Officers don't get a privacy shield for statements made while performing their public job on your doorstep. Now, here's the practical piece, the setting that actually determines whether any of this survives even if someone does manage to cover your lens. If your camera saves footage only to local storage, a chip inside the device itself, then blocking the lens or disabling the unit can wipe out everything, including footage of the moment leading up to that action. But if your system is set to upload continuously to the cloud the second it detects motion, the footage is already off the device and stored somewhere the person standing on your porch can't touch. That means the footage of officers approaching, and very often, footage of the exact moment a hand reaches toward the camera, is preserved before the lens ever goes dark. That's actually how the Little Rock incident became public knowledge in the first place. It wasn't the homeowner's own camera that captured the caravan of vehicles arriving, since that unit had been taped over almost immediately. It was a neighboring camera with a different angle. So, do two things today. First, check that your doorbell camera is set to cloud storage and not local only. Second, if it's feasible, consider a second camera positioned somewhere less obvious than the front step. When there are two witnesses instead of one, covering a single lens accomplishes nothing beyond capturing someone's own hand doing exactly that on video. Now let's get to the actual language. the words you want locked in your memory, because in a stressful moment, your brain will not improvise a legal argument for you. Say this calmly, either through the closed door or the two-way speaker on your camera itself. You never need to physically open the door to say it. Officer, I don't consent to you touching or covering my camera. I'm not opening the door. If you have a warrant, please hold it up to the camera. Otherwise, I'm asking you to leave my property. Let's unpack why each part of that sentence is pulling weight. Stating clearly that you don't consent to the camera being touched puts your objection on the record, in your own voice, on tape, so there's zero ambiguity later about whether you agreed to it. Declining to open the door shuts down the exact mechanism that turns a routine knock into something closer to a search, without you needing to be confrontational about it. Asking for a warrant to be shown through the glass is the real pivot point. If one genuinely exists, he can display it right there, and if he can't or won't, that tells you everything you need to know, and it's captured on video. And formally asking him to leave your property revokes that implied license the Supreme Court described. From that point forward, every additional moment he lingers is a choice he's making to remain somewhere he's been asked to leave. Be ready for pushback, because you'll likely get some. If he asks why you won't open up if you have nothing to hide, don't take that bait or start explaining yourself. Just repeat your line. Not opening the door, show a warrant if you have one. If he insists the camera is a safety issue and needs to come down, repeat your non-consent calmly once more, without getting drawn into a debate about his safety concerns on your own property. If he suggests you step outside to talk more comfortably, recognize that as the porch trap wearing a nicer disguise, stay put and say you're glad to talk exactly where you are through the door. And if he simply won't leave, if the knocking continues, the pressure to come out ramps up, and he lingers well past the point where a normal visitor would have moved on, understand that the nature of the encounter may have shifted. A knock and talk only works if you're voluntarily participating. Once that voluntary framing breaks down, you may be looking at a detention, and that's a different legal category entirely. Either way, your job stays the same. Remain calm, remain inside, keep repeating short, clear statements, and let the camera do the heavy lifting. At the end of the day, that little camera above your door is the one participant in this entire scenario who can't be talked out of what they saw, pressured into a different version of events, or worn down after hours of questioning. That's exactly why disabling it becomes the priority before a single sentence is spoken. Now you understand the reasoning behind it, you know the legal footing beneath your feet, and you know the two adjustments that make sure the truth gets preserved, even if someone tries to erase it in the moment. A knock at your door isn't the whole conversation. It's just the opening move, and you get to decide how much of it you actually play. Keep your door closed, keep that camera rolling, and let the recording speak for you.